All right, let's dive into what happens when a disaster strikes out on the water. It's not governed by the laws you and I deal with every day. Nope. It's run by a strange, ancient set of rules called Admiralty Law, and it has shaped global commerce for centuries. You know, when things go wrong at sea, it's nothing like a fender bender on Main Street. You really have to forget everything you think you know about personal injury or property damage. See, incidents on the water, they fall under a completely different and frankly much older set of rules. So to make sense of all this, we're going to follow a single hypothetical incident. Picture this. A massive commercial ship collides with a small pleasure boat. We've got an injured person, a wrecked yacht, and millions of dollars of cargo sitting at the bottom of a river. This one crash is going to be our guide through the very peculiar world of Admiralty Law. Okay, so right off the bat, the owners of our two vessels are in for a huge surprise. They can't just head down to the local county courthouse to sort this out. In fact, their local state court has absolutely no power to hear this case. And that's because Admiralty Law is what's known as an exclusive federal jurisdiction. This power goes way, way back to Article 3 of the U.S. Constitution. So the case completely bypasses the entire state system and goes straight to a federal judge. The whole idea is to have one single, uniform set of rules for commerce all across the country. Now, here's where it gets really interesting. The key test for this federal power isn't whether you're in the ocean. It's all about whether the incident happened on navigable waters, which is a surprisingly broad term. If a river or a lake could be used for commerce between states, even if it isn't right now, it falls under federal jurisdiction. And, this idea has really grown over time. It used to be just about waters that were affected by the ocean's tides. But then, in 1851, a case about a collision on Lake Ontario called the Genesee Chief completely changed the game. The Supreme Court expanded that definition to include America's great inland waterways, recognizing just how vital they were to the nation's booming economy. Okay, so our case is in federal court. That's settled. But how in the world does the judge actually figure out who was at fault for the crash? Well, here again, the rules are totally different from anything you'd find on land. So think about a car accident. You have to prove the other driver's mistake is what caused the crash, right? Well, in Admiralty Law, the burden of proof can get completely flipped on its head by something called the Pennsylvania Rule. If one of our boats violated a safety rule, let's say it didn't have the proper lights on, it is automatically presumed to be at fault. The only way out is if it can prove its violation could not possibly have contributed to the accident. And let me tell you, that is an incredibly high bar to clear. And this really highlights another key difference in how things work. It used to be that if both boats were even a tiny bit at fault, they'd just split the damages 50-50. That was the old moiety rule. But today, the courts use a much more logical, proportional fault system. So if a judge finds the big cargo ship was 90% responsible and the little yacht was 10% responsible, that is exactly how the damages get divided up. Now, let's switch gears and talk about the lost cargo, because this is where the rules start to feel truly counterintuitive, especially for the poor owners of all that stuff now sitting at the bottom of the river. So, when you ship goods by sea, everything, and I mean everything, revolves around a document called the Bill of Lading. It's this fascinating piece of paper that's like a Swiss Army knife. It does three things at once. It's a receipt, proving the carrier has the goods, it's the contract to transport them, and it's a document of title, which means you could literally sell the cargo while it's still on the ocean just by handing over that piece of paper. The entire relationship between the person shipping the goods and the company carrying them is governed by a federal law from 1936. It's called the Carriage of Goods by Sea Act, or COGSA for short. And let me tell you, it contains a major, major surprise for shippers. And here it is. Under COGSA, unless the shipper specifically declares a higher value and pays extra for it, the carrier's liability for a lost or damaged container is limited, not to the actual value of the goods inside. Oh no, it's limited to just $500 per package. Yes, you heard me right. That entire container, maybe with $1 million worth of electronics inside, legally it could be valued at just $500. But believe it or not, that's not even the biggest shocker in Admiralty Law. The owner of that cargo vessel has access to a really powerful and pretty controversial tool that can limit their total financial exposure for the entire disaster. So this raises a huge question, right? We have an injured person, a completely wrecked yacht, and millions in lost cargo. So how is it even possible for the cargo ship's owner to limit their liability for the whole catastrophe, not just one container? Well, the answer lies in a law that was passed way back in 1851 called the Limitation of Liability Act. It says that if an accident happens without the owner's direct knowledge or involvement, their total liability for all the damages combined is capped at the value of their vessel after the accident has already happened. And here's the crucial point. The math here can be absolutely staggering. The cargo ship company might be facing, say, $15 million in total claims. But if their vessel was heavily damaged in the crash and is now only worth $500,000 in salvage, well, under this act, that $500,000 figure could be their total payout for the entire incident. Now, you might be thinking this sounds incredibly unfair, and there is one critical exception that's meant to prevent abuse of this rule. The owner can only limit their liability if the accident happened without their privity or knowledge. So if a corporate executive back at headquarters knew the ship's radar was broken or that the captain was dangerously overworked and they sent the ship out anyway, they lose this protection. They have to pay the full amount. So why do all these strange and sometimes really harsh rules even exist? Well, it all goes back to the original purpose of Admiralty law, which was to encourage and protect maritime commerce. By limiting the enormous financial risks of sending a ship out to sea, these laws made it possible for investors to fund the shipping industry that built the global economy we have today. And all this leaves us with one final, pretty provocative thought. These laws were designed for the age of sail, when a ship owner might not hear from their vessel for months at a time. So in today's world, with instant communication, complex corporate structures, and billion-dollar megaships, are these 19th century legal protections still fit for purpose? Or to put it another way, are they still seaworthy?